Modern Real Estate Practice Workbook, page 40. Key points. Unit 3. When title to real property is held by one person or entity, it is called ownership in severalty. Property may be owned solely by one individual or by a single entity, a corporation, partnership, limited liability company, or real estate investment trust. Concurrent ownership or co-ownership exists when two or more people simultaneously share ownership of one piece of property. The two most common forms of co-ownership are tenancy in common and joint tenancy. In many states, unless an agreement exists to the contrary, co-ownership is presumed to be a tenancy in common. With a tenancy in common, there is an equal right of possession, but each tenant may hold unequal shares of ownership and there is no right of survivorship. With a joint tenancy, each tenant must have an equal ownership share and equal right of possession. Joint tenants also have a right of survivorship. This means that when a joint tenant dies, his share of ownership in the property automatically passes to the surviving joint tenant. Common interest communities include condominiums, townhouses, cooperatives, timeshares, and planned communities. Sales of these types of properties are generally regulated under an individual state's Common Interest Ownership Act. The owner of a condominium unit owns the unit plus an undivided interest in the common elements as a tenant in common with the other unit owners. A cooperative, by comparison, is a building owned by a corporation. Each resident owns shares of stock in the corporation and has a proprietary lease in the individual unit. A deed is the document used to transfer real property. A valid deed must identify the parties, have a competent grantor, contain words of conveyance, contain a legal description of the property, state that the consideration was given, be properly executed, and be delivered and accepted. The statute of frauds requires that the deed be in writing. The three main types of deeds used are the general warranty deed, special warranty deed, and quitclaim deed. A general warranty deed carries 5 basic covenants: seisin, quiet enjoyment, against encumbrances, further assurance, and warranty forever. This deed provides the greatest protection for a grantee, typically the buyer who is receiving title to real property. A special or limited warranty deed warrants title only for the time the grantor owned the real estate. Unlike a general warranty deed, it does not give any warranties for past or future claims unless the claim is for the period the grantor owned the property. A quitclaim deed conveys no warranties of any kind. It simply conveys whatever interest the grantor has when the deed is delivered. A quitclaim deed may be used as a problem solver to clear clouds on the title. When a person dies, the person's property may be transferred by the terms of a will or according to the rules of descent, which govern intestate succession. Property may also be acquired by adverse possession. The adverse possession must be open, continuous, exclusive, actual, and notorious, hostile, for a period of years that are determined by each state.